Normally what happens is you've got a local campaign group or even an individual or can be a national NGO, and they're concerned about the process of the consultation. And so sometimes they will come to the lawyers while the consultation's even going on or even before it started. But very often they will come after the consultation's closed and the decision's been made, and they'll come along and they will say, we think this consultation wasn't conducted properly. So what then happens typically is we will sit down, we will look at the documents, we will talk to the people who are concerned, whether that's the local campaigners, whoever it might be, and we will try and understand what they say went wrong in the consultation. And very often they will say, they weren't listening, or the questions weren't clear, or there wasn't enough information. So once we've discussed with them, we've looked at the documents, we work out what we think has gone wrong by reference to the law on consultation. The legal process that's then involved is what's called judicial review. So that is the court process where people can challenge the legality of anything done by a public body. So that's simply a court process. First step in that is what's sometimes called in the newspapers and the media, they will call it a legal letter. In the trade, it's normally called a letter before action. So what that is, you're really required by the court rules to write to the organisation that you might be thinking of challenging, tell them what you think's gone wrong, and give them a chance to sort it out. So the idea is that the problem can be resolved without going to court. So the obligation on you before you bring your action, your legal claim, is to give the other side a chance to sort out the mess. You then give them typically 14 days to respond. So you sit and wait for the response. They write back. Sometimes they write back. Occasionally they write back and say, oh, you're absolutely right, we'll do it again. Doesn't often happen, but sometimes they do that. If they don't do that, you then have to decide whether you're going to progress to the next stage, which is actually the legal challenge. So now things get serious. This is where you're actually into proper court territory. So again, the lawyers sit down, they prepare the documents. Typically for a consultation kind of case, you'd end up with a file of documents sort of the size of a lever arch file, with all the relevant paperwork in and an explanation written by the lawyers as to what's gone wrong, and very often a witness statement from the claimant explaining their concerns in more common sense terms. That goes off to the court. It also goes to the other side. They have 21 days to respond to that. So they put in their response to the court, explaining why they say the consultation wasn't unlawful. So what is their explanation? How did they comply with the legal requirements for consultation? That paperwork, so your file and the other side's file, then goes to a judge. And at the initial stage, there's a sort of filtering, which is designed to weed out completely hopeless cases. So those two files effectively go to a judge sitting in their office, and the judge looks at it and says, is there something in this? Is this an arguable case? That's what's called the permission stage in the trade. Yep. So if the judge thinks there's something in it, it's an arguable case on a quick read, the judge gives you permission for judicial review. So that's stage one. If you've got your permission for judicial review, you can then carry on to the next stage, and the next stage ends up in a proper court hearing. In the run-up to that court hearing, each party can put in more documentation, they can put in evidence, they can put in witness statements, they can put in more complicated legal arguments. But again, that simply gets you to what's called the substantive hearing, which is where the court decides the legality in the end. You then go along, the barristers stand up in front of the judge and argue. The claimant says the consultation was unlawful and this is why it was unlawful. The defendant's barrister says no, it wasn't because we didn't do it that way, or you misunderstood the law, or whatever it might be. Claimant's barrister responds to that, so it's bang, bang, bang. Everybody goes away, judge goes away, scratches their chin. It might be a week, might be 2 weeks, might be a month, might be a couple of months. Judge gives their judgment. So normally then the judge's judgment is 20, 30, 40 pages of written explanation where the judge explains how they have decided the case. They analyse, they explain the factual background, they explain the legal arguments in their judgment, and they explain what their conclusion is. And that's the judicial review process. So that might take anything from, if you're in a hurry, that can sometimes take as little as 3 months, but it can take much longer. It can take a year or 18 months if there's no particular urgency in the situation. So typically they take anything between 3 and 12 months from beginning to end. So that's what I do. That's my daily life.
Your life in a nutshell.
My life in a nutshell.